Mr. Meisner, sitting with us to my right, is a well-known, I've known him for some time. I know who he is. He's a writer, an author. He is an attorney. His practice is called the Meisner Law Group. He's been practicing law for 45 years, long time. Graduated from the University of Michigan Law School. He co-drafts, what is that? Person of a 1978?
The Condominium Act.
Condominium Act.
Co-drafts person.
Yes. How many here are from a condominium? Do we have any condo people here? Oh, I'm sorry. No, I guess not. We don't care about condos yet, anyway. Not only the act, but the amendments to the act in 2002. He has been a columnist for Real Estate Questions for a long time for the Observer Eccentric, the hometown newspaper. He's co-authored a book on condo living, too. Next, you're going to co-author a book on associations.
That's same issue.
Same issues, okay. He's a former adjunct law professor at Michigan State and Cooley Law Schools, and first of only two indicted in CAI.
No, I wasn't indicted.
Inducted. I'm sorry. I'm dyslexic, so sorry about that, Bob. You will forget.
There are a lot of people that like to see me indicted.
I know that.
I haven't had that happen yet.
You don't want it? Okay, I can understand that. So he was inducted in the CAI, Community Association College of Lawyers. It's quite a resume, and we do appreciate your coming here. Mr. Meisner, Bob, can I call you Bob?
Sure.
Okay. We'll talk to you about associations, why we're there, what we do, what our responsibilities are, and there'll be plenty of time for questions. If you think of something while he's talking, if you'd write it down and wait till after he's through, that would be perfect. And we look forward to your questions. We hope this is very informative for both you and your association. So, Mr. Meisner, Bob.
Well, thank you very much, Sue, for the introduction, and thank you for coming out on a gloriously warm Saturday morning based on what we've been through. I will try in the next hour or so to give you some insight into some of the issues that I see. And let me first say that even though no one in here is involved in a condo, the issues regarding the government and governance of a community association are basically the same. The Nonprofit Corporation Act applies to more than likely every one of your associations, and it applies to condo associations. And you are so lucky today because just recently, as of January 15, 2015, there have been major changes to the Nonprofit Corporation Act, which we are frankly in the process of evaluating at this point in time. So you will be maybe the first in your neighborhood to hear about some of the changes to the Nonprofit Corporation Act that obviously affect each and every association. So let me try to go over some of the basics. How many of you are on the boards of directors of your associations? Most of you are. Okay. Anybody get paid for doing that? Anybody appreciated by their members for doing that? Okay. If you walk out of here with nothing else that you get from our discussion this morning, it is that you are liable for your acts or omissions. And what I've been preaching for years and years in community association classes that I teach, and by the way, we do offer and have for years, it's called Advanced Condo Operation, but it really is a study of various issues that come up in community associations. Bylaw enforcement, collection of assessments, fiduciary duties of directors and things of that sort. And it's offered through our office in Bingham Farms starting in May, And if you're interested, we have a brochure up here, or you can obviously contact our office. It's a 4-week course, 2 hours a night, typically from 7 to 9 on a Tuesday night. And it's relatively inexpensive, and it's very informative, and we've been doing it for 40 years. Okay, let's talk about some of the parties involved in the community association or the homeowner association. First of all, there is the association itself, which is typically a nonprofit corporation. And it has members, namely the people that live in your subdivision. Typically, your subdivision documents, your deed restrictions, your declaration, whatever it's referred to, will provide that anyone who owns a unit or a house in that subdivision will be automatically a member of the association in most instances, and therefore will be bound by all the restrictions that are contained in the declaration and in the bylaws. Now, just like any other corporation, there is a board of directors. Typically, the board of directors is elected by the members of the association. The board of directors calls the shots. They make policy, they make decisions. And they incur the liability because they're in that fiduciary duty, which we'll talk about later. Now, the directors typically have the right under the bylaws, and again, I'm only talking in generalities here, and no one, by the way, this is a disclaimer, no one out there should ever rely on anything I'm saying as legal advice, okay? But as a general matter, the bylaws provide that the directors will appoint officers: president, vice president, secretary, treasurer. There is always confusion, even among the most sophisticated people, as to what the difference is between a director and an officer, and there's a major legal difference. The officers are appointed by the board, typically can be removed by the board of directors, and only have the powers that are vested in those officers by the bylaws, or more typically by the board of directors. So unless the board of directors tells the vice president to sign an agreement, that vice president may or may not have the authority to do that. The authority comes from the board of directors. Where the confusion comes in is that typically the directors are the same people as the officers. The directors are elected and they appoint themselves as officers. Some bylaws allow you to appoint other people as officers. Some bylaws don't even require that the directors be members of the association, which is unusual. So it's important to understand the difference between directors and officers. Oftentimes I hear, oh, we elected officers at our annual meeting. No, probably not. You elected directors of the association who then appointed officers at a meeting of the board. So, a couple other general comments. As a nonprofit corporation, I'm sure you know you have to file an annual report in behalf of the association every October 1 to keep it in good standing with the state of Michigan. Otherwise, if you don't do it for a period of years, your association, nonprofit corporation, could be dissolved, and that ends up being resulting in potential personal liability for not only the quote board of directors, but everybody in the association. Now, you would be surprised, particularly if you're self-managed. If you have a management company, generally speaking, they take care of that for you, or they should take care of that for you, and making sure that the annual report is filed with the state of Michigan. In a self-managed community association, a homeowner association, where you're typically underfunded, in my opinion, because there are restrictions in your documents that limit how much you can assess the homeowners every year, together with the reluctance on the part of the board of directors to raise assessments, which I would think are necessary to deal with the issues that come up at the community association. And let me digress for a second upon that. In a condo project, the board, under the statute and the bylaws, has the right to levy assessments and additional assessments. And typically, there is no limitation on the amount of assessments that can be levied. It's based upon the budget for that condo association every year. In a homeowner association, typically the developers, when they do the homeowner association, have limitations on how much the assessment can be to begin with, and make it extremely difficult as a practical matter to get the approval of the homeowners, or it requires the approval of the homeowners to raise that assessment. So homeowner associations that typically don't have the same maintenance responsibilities as, say, a typical condo project, their assessments are modest, in fact, below being modest. And you get along, okay, you take care of the cul-de-sac, and you take care of some grass cutting and things of that sort. And so you barely get by, and you don't have any reserves because you don't own any real estate. However, what happens when the homeowner decides that he's going to paint his house purple, which I happen to love. I happen to love purple. But the bottom line is, let's assume that he wants to paint his house purple. And that's against the deed restrictions. And you got $2,000 in your account over and above what is necessary. Now, if that homeowner has any sense, he's going to know that your association is not economically available to be able to pursue him in court. And if he's a tough guy, he'll know that. Or if he's a smart guy, he knows that. Or if he calls me, he'll know that. Because typically that's what happens. Let's assume that the guy let's assume your assessments are $125 a year, when maybe they should be $1,000 a year, realistically. And I'm not kidding about that. And a homeowner doesn't pay his assessment. Typically the board will say, well, you know, it's only $125. Let's let him go 2, 3, 4 years. So maybe it reaches $500. And then finally somebody gets the notion that, hey, you know, maybe we ought to do something. Well, again, it's going to cost you a lot more than that to go after the homeowner. But you may not have the monies to do that. And hopefully you have a provision in your deed restrictions that provides for the recoupment of reasonable attorney fees. Now, we know when we talk about reasonable attorney fees, we're talking about an oxymoron, right? Okay. But, you know, the bottom line is that you want to be able to have the ability financially to deal with problems that are likely to come up, because it is your responsibility as a board to do that, plain and simple. And if you don't have the economic funds, and you shouldn't be waiting 4 years to collect assessments, I don't care what the amount is. You need to have a collection policy in place and a deed restriction policy in place, and that's something that we talk about in something that we call a 12-pack, which is what we offer to community associations that like to drink beer. And so we give them no, it's not alcoholic, it's non-alcoholic, it's a series of procedures and documents, one of which is a collection policy, and one of which is a bylaw enforcement policy. So keep in mind that if your association is underfunded, you're not going to be able to do your job. Or you're going to, when the job comes before you, you're going to not do it. You're going to say, oh, we're not, you know, he's a friend of mine, he lives across the street from me, let's, you know, it's only $125, you know, we can do without it. No, that's not how you run the business of a community association, and it is a business. And even though it's your residence and it's a nice, friendly residential community, it is a business. It's a nonprofit corporation. You have the same basic liability in most instances as any director of any corporation, whether it's General Motors or anybody else. Now, you have certain exclusions that the Nonprofit Corporation Act allow you to avail yourself of, which we'll talk about a little bit later. But in the last analysis, and somebody will say, well, we have insurance. And maybe you have an indemnification clause in your restrictions. And my sort of silly comment to that is, hey, you have insurance on your car. Do you drive down Telegraph the wrong way because you have insurance? No. You want to be careful and cautious about the way you do business. And it's the same being on the board of a community association. Okay, one other basic comment. Every nonprofit corporation has to have a resident agent and a registered office. And the reason, make sure you file your annual reports. The purpose for the resident agent is that tells the state of Michigan who it should contact in terms of any official business of the association. And it's also the place where you get served if you're being sued, for example. If we're having to sue a community association for some reason, we have to serve the resident agent. Typically, the resident agent is either the management company or in many instances where the lawyer is the resident agent. It's a non-paying job. It's just a form that's filled out. But frequently, we find that notices, bankruptcy notices, or tax notices, tax foreclosure notices, mortgage foreclosure notices, sometimes are sent to somebody who is a member of the association but not around or not is dilatory about looking at their mail or whatever the case is. So you're probably best off having an independent third party, either a management company or the attorney, serve as your resident agent, so that if there is some legal document that has to be served, it gets into the hands of the attorney. Okay, let's talk about understanding the community governing documents. Most of you obviously live in a subdivision which created a homeowners association. You will have a declaration. It may be called building use and restrictions. You'll have bylaws, which are basically corporate bylaws and facilitate your ability to operate as a homeowner association. It'll tell you how many directors you have, when you have your annual meetings, what the duties of the officers are, how you remove directors, and things of that sort. You will have a set of articles of incorporation that were filed with the state initially in order to establish the nonprofit corporation. As you will hear later today in my discussion, there have been changes to the Nonprofit Corporation Act, which some of these changes should be embodied in the Articles of Incorporation. Why? To enhance your ability to be free from liability. So that's very important, the Articles of Incorporation. They're a matter of public record. They're on file with the state. Now, all of you have an individual warranty deed, presumably to your house, which will probably provide on it a statement that it's subject to building and use restrictions, which are the deed restrictions that we're talking about, so that every home presumably in your subdivision is bound by those restrictions. Now, let's talk about rules and regulations and policies. There is always some confusion, and there's confusion legally among lawyers for the difference between a deed restriction, no dogs, no purple houses, no barbecuing on your patio, and a rule or regulation. Garbage will be picked up at 7 o'clock on Tuesdays. And the reason there's confusion is because sometimes they're very similar in nature. When you pick up the garbage on Tuesday is probably a prohibition on activity, just like you can't have more than 5 dogs in your house. However, there is a legal difference between the two, and typically a deed restriction is what the Supreme Court has said is the structural law of your development. Namely, it has been established typically by the developer or declarant originally. If additional restrictions are added to the documents, they will have to pass a certain or obtain the approval of a certain percentage of homeowners. Now, the board of directors has a certain power to make rules and regulations, but they can't change the structural law, as we put it. They can only implement the structural law that's already there. So what I'm suggesting to you is that if the Board of Directors has the right to pass rules regarding the common areas, if there are any common areas, they can decide, well, what time is the park going to close, or what time is the pool going to close, or, things of that sort that are really implementing the existing powers that they already have. The punchline for you is recognize that there is a difference between rules and regulations on the one hand and deed restrictions on the other. And if something is trying to be passed that rises to the level of a deed restriction, typically you're going to need a certain percentage of people in that community to pass it. Whereas if it is something within the rule-making power, it is something that the Board of Directors has the right to promulgate. So that's something to keep in mind. Okay. And somebody mentioned earlier, and I think this is a good time, there's nobody here who's a condo owner, maybe not here at least. You're condo owners. Okay, this is a book that we just recently published through Momentum Books, our magazine subsidiary, and it's called Condo Living 2, the authoritative guide to buying, selling, and operating a condo. But if you look at it, it basically covers, besides the issues that you have in buying a condo, which is not all that different from buying a home, other than you don't have to worry about in a home, you don't have to worry about the next door neighbor's home because you're not responsible for maintaining it. In a condo, you would be, potentially, under the documents. And so it does discuss the role of the Board of Directors. And the role of the Board of Directors, whether it's in a condo or a co-op or a homeowner association, is basically the same. And some of the issues that come up in the governance of the association are applicable across the board, regardless of the nature of the community association that you have. Okay, now let's talk about recent changes in the laws, and I mean recent. I mean like a month ago, less than a month ago. So I'm not going to opine on the statute or the changes as to whether they're accurate or enforceable or inconsistent or not with other situations. I don't have to worry about whether the changes to the Nonprofit Corporation Act are in conflict with the Condominium Act, because we don't really have that issue here today. But let's talk about some of the changes that have been made, and it is clear that you will have to, if you're being responsible, implement some of these changes or have your lawyer, hopefully, implement these changes in your documents. Record inspection rights. Now, what typically happens is that nobody really cares about the way you keep books and records of your community unless they're upset about something. That's typically the case. They're upset with the board about whatever the case may be. Now, I realize that's a generalization, but based on my 40 years plus of doing this stuff, the first thing that an irate homeowner is going to say is, I want to see the books. I don't think money's being spent properly and things of that sort. So, the prior law said upon at least 10 days written demand, a member could inspect during usual business hours the minutes of membership meetings, the roster of members, and to make copies, but only if it's for a proper purpose. So the statute called for a proper purpose. Now, nobody really knows what a proper purpose is, but if they're doing it just to be vindictive and punitive, and you suspect that that's the case, it gives the lawyer an opportunity to say, you know what, you're not doing this for a proper purpose. You really don't care about the financial affairs. You're really trying to get back at the Board of Directors and try to find some slip in the accounting or make them go through the trouble of doing that. Now, under the new law, within 5 business days of receiving a proper demand, whatever that is, the association shall, which means it must, permit an inspection of the books, records, and membership roster. And failure to permit the inspection or imposing unreasonable limitations on that inspection could result in a court ordering the association to pay the members' costs and attorney fees, unless the association can demonstrate good faith because it had a reasonable basis to doubt the right to inspect. Now, I think that's a good change, because number one, everybody complains to the legislature, hey, they won't, I can't get any response from the board, and we don't have a right to look at things. Well, they do. They always had a right to look at things. Sometimes they have to get a lawyer to do that, and they don't want to spend the money to do that, which is unfortunately typical. Well, now at least there's a statute that sets some parameters for when the board of directors has to allow the inspection, if it's for a proper purpose. And it gives the association an argument, at least, if they refuse to turn over those books and records, that this was not done for a proper purpose. Now, I quote, proper demand, and that's a word of art that was in the statute, is met under the following conditions. 1, the member provides written demand stating the purpose of inspection with reasonable particularity. In other words, if the guy comes in and says, I want to see everything, and I don't care what it is, I want to see your books for the last 10 years. No, that's not reasonable, that's not realistic, and that's not with reasonable particularity. 2, the member can inspect books, records, and membership roster if they are directly connected to the stated purpose. So if he's worried about how much you spent on the landscape contractor, he can't look at the salary of the manager of the project or the maintenance guy. So it's got to be related somewhat to the purpose of the inspection. And 3, proper purpose is defined as, quote, reasonably related to a person's interest as a member. How vague could that be? Everything is reasonably related to a person's interest as a member. Maybe he has an interest in impugning the board of directors. Maybe he has an interest of being vindictive. Okay, so unfortunately, in the legislature's effort to help things, they have oftentimes created more problems than they have created, which of course is great for lawyers, right? Yeah, okay. Anyway, now let's talk about the next change. You didn't seem to agree with that. All right. Well, it's like the tax changes. They do that for the CPAs, right? Any CPAs in here? You love tax changes, okay? Because it makes you start from the beginning, go from there. Member proposals included for meetings. Under the new section, it adds to existing requirements that the association shall include in the notice of meeting any proposal a member wishes to include in the membership meeting. 1, if the proposal is a proper subject for member action, and 2, the member notified the association in writing of his or her intent to present the proposal at the meeting. Now, that's very interesting because it does open up the ability of a member of an association. And it doesn't really talk about what kind of meeting we're talking about here, presumably the annual meeting, because there's no Open Meetings Act in Michigan, which means that, and this is something to keep in mind, the board of directors does not have to allow any members of the association, other members of the association, to attend their board meeting. It's not like Florida, others, California, or other states, where you have to give notice of the board meeting, and you have to allow the people to come to the board meeting and participate, except in executive session, where you get into issues such legal issues and things of that sort. So presumably they're talking about the annual meeting here. And if you're frustrated about what an association is doing or not doing, you can put a proposal on the ballot or at the membership meeting for consideration. Now, again, that may conflict in some respects with the Condominium Act or the condominium bylaws that normally provide for a certain percentage of people to be able to move to have something placed on the agenda or to modify the condominium documents. In a homeowner association, what this does is if you want to put something on the ballot or at the meeting for discussion, and it's for a proper purpose and it's within the scope of the membership's ability to take action, now you can do that. And that's, I think, an improvement to some extent. But again, like every other change, it can be abused. Because now you're going to have a question is as to whether the proposal is a proper subject for member action, and has the member notified the association adequately in advance. And I could see where this could be an area of abuse, because the membership may get maybe one faction of the community says, okay, we want to put 5 or 10 different items on the agenda. We want to slow up the annual meeting. We want to use this as a political weapon to embarrass the board of directors. Don't spend as much money on the landscape contractor. We want a resolution to that effect, or whatever the case may be. So, as in every type of legal change to the documents or the law, there are good points and there are potentially bad points. And it depends how things work out here. Okay, next change, electronic changes regarding remote meeting. Kind of an important change. In 2008, the Nonprofit Act was amended to permit electronic voting, to permit electronic notifications of meetings and other association matters, to allow remote participation in meetings. Okay? Under the 2008 amendments, electronic voting and remote participation were only permitted if the articles of incorporation and/or the bylaws were amended to allow for same. So, in a number of our, in most of our condo association and homeowner association clients, we obviously wanted to take advantage of this change. Now, remote participation is permitted without an amendment unless specifically restricted in the document. So, I doubt if people are going to amend their documents to say, no, we don't want remote participation. However, I've seen community association documents where they don't allow proxy voting. So it depends on what the developer or the declarant had in mind when he did your documents, what the particular nuances of your community association are as to whether or not you think this is a great idea or not. More than likely a good idea, but as in every other situation, there are always exceptions. Okay, let's go on to limitation of liability, directors, officers, and others.
Can I ask a quick question on it? Does that, like...
No questions now.
Email?
You have to write them down.
Oh, yeah. All right.
We have to, we have to wait to the end, and I'm happy to do that. But otherwise, if we open up the floor, then I'll never get out of here. Okay. Plus, I don't know the answer to your question. All right, moving right along. Limitation of liability, directors, officers, and others. This is one of the most important sections of the Nonprofit Corporation Act to protect the associations and encourage more people to serve as directors, officers, and others on committees and things of that sort. Section 209 of the Nonprofit Corporation Act, which was originally passed in 1983 and now has been amended for the third time. These protections must be in the Articles of Incorporation by way of an amendment to be effective. Now, if your associations don't have these protections already, it's like driving down the street without inflated tires. Because the Nonprofit Corporation Act, starting in '83 and various changes to them after, exempted you from liability as a director and later as an officer and volunteer under certain circumstances. So if your articles of incorporation were never amended, shame on you, or shame on your predecessors, because you're not taking advantage of what the legislature and the law has given you, okay? Now, having said that, there's a new amendment that was passed that says the following: directors who are not limited to volunteers and volunteer officers are limited from liability for money damages for, quote, taking any action or failing to take any action in behalf of the association. I hope it wasn't anything I said. Exceptions to this protection remain the same for improper financial benefit received, intentional cause of harm, intentional crime, and the like. Okay, this is a very interesting change because before they talked about fiduciary duty, and that covered a lot of things: conflicts of interest, self-dealing, things of that sort. Now they're saying you are exempt from liability because you didn't take some action or you did take some action. And I'm not sure I understand exactly what the intent of the legislature was. I'm not sure that this is either an expansion of your exemption from liability or a limitation of your exemption from liability. It may be an expansion because taking action or not taking action, that's typically up to the board of directors. Are you going to sue somebody or not? In terms of what they've done, you have to make a business decision based on that with the advice of counsel. On the other hand, if you're in a conflict of interest, I don't think that has anything to do with taking action or not taking action. So this may be actually a limitation on the exemption that board members had. Okay, so that's something that, these are all issues that you need to grapple with now because they affect every one of your associations. And, if you got $500 in your legal account, you're not going to make it. This is a typical example of why community associations need not to be underfunded in terms of how they run their business. Because more than likely, you're going to have to amend your documents. And if you take your documents into somebody who knows something about it, they're going to say, oh, you haven't amended your bylaws in 27 years, and your declaration is your original declaration. And, you've got provisions in there that are illegal, fair housing violations, and you left them in there even though you don't enforce them, and that may have a deterrent effect on minorities being able to buy into your community. Therefore, we're going to sue you under the Fair Housing Act or the Elliott Larson Civil Rights Act. So if you have not done your due diligence in making sure that your documents are up to date and that your deed restrictions have been amended to deal with 2015 issues and not 1967 issues, okay, fine, that's what you need to do. If you haven't, you got a problem, potentially. And you always have to keep in mind that it only takes one homeowner who gets upset or who is reasonably upset about the manner in which that association is being run to cause you great grief. And guess what? You are personally liable as a director for what you do or don't do, except this may protect you a little bit, assuming you implement it. Okay? Removal of directors. This was and many times your bylaws will provide a procedure for removing directors. Typically, it requires a certain percentage of the homeowners, usually a majority of all the homeowners, at a meeting called to have an election to remove them. That's typically what's in these bylaws, but under the Nonprofit Corporation Act, this was, as I said, previously dictated by the bylaws or articles. The new law says any association or 1% of the members. 10%. 10%. Okay. Typo error. Okay. Yeah, 1% didn't seem right, did it? Any association or 10% of the members can petition a court, yay, to have a director removed for conduct that is fraudulent, illegal, or dishonest, or for gross abuse of authority or discretion. Great idea. Now, whether you're ever going to get 10% of the people to hire an attorney to do that is another matter, is a practical matter. Because people don't want to get involved, and they frankly don't care, as long as their grass is cut. Okay? But those that are concerned about the operation of the association should and will care. And the association itself, which means the rest of the directors, theoretically. Let's assume you got one bad apple on your board. And you don't think you're going to be able to get a number of people sufficient to remove that director, because you got 350 homes, you're never going to get a majority of 350 to show up at a meeting, let alone try to remove a director. So now you have, at least under this statute, the ability to take it upon yourself to do it. So, I think that was a good improvement. Again, how much it's implemented is another matter. Okay, taking action without a meeting, voting by ballot only. Another opportunity for you to take advantage of the Nonprofit Corporation Act to facilitate your ability to amend your documents and take other action. Our experience is that it is very difficult to get people to come to a meeting for any reason, unless you've raised the assessments or have an open bar. Those are usually the two opportunities to get people at a meeting. Okay? But short of that, they don't come. And if you have a 2/3 requirement or a 75% requirement to amend your documents, it's very difficult to get that type of approval. So sometimes you have to, we go through we've up until this point at least, we've had to go through a step-by-step process. In a condo or a homeowner association, typically we'll get their articles of incorporation amended to begin with to allow for taking action without a meeting. And what that simply means is that you send out a proposal to the members. You may have an informational meeting first where you invite the members to come and explain why we want to amend their documents. And we'll give them a form and we'll say, look, here's a ballot. You got 60 days to approve this amendment. And we'll try to get them to sign the approval at that meeting. And then they got 60 days, we give them notice. And then we ask the association board or their committees to go out and knock on doors and try to get them to approve this thing, because they're not going to come to a meeting. And hopefully you get the necessary approval to get it done. Now that's typically what we've done where we've had a problem getting, the generally higher than majority requirements to get the approval of the documents. Now, prior to now, this clause had to be in the Articles of Incorporation to be permitted. Now it's okay to be in the bylaws. A lot of you may have this provision in your bylaws, but not in your Articles of Incorporation. So up until now, we had to amend your Articles of Incorporation to include that provision. But if it's in your bylaws, it's okay now. The new law allows for action to be not less than 20 and not more than 90 days. The prior law was silent, so the document meeting notice requirements dictated this, usually 10 to 60 days. So now there's some parameter between 20 and 90 days to get the job done. The new law states that ballots cannot be revoked unless the bylaws or articles allow for it. Now, you may want to have an amendment to your documents to allow somebody to revoke their ballot. If you're in a political contest, which frequently is the case in a condo or community association or homeowner association, people are running around getting proxies and trying to get ballots. And now if you can do this with respect to directors, it's clearly going to be the case. There'll be political battles going on. And people will be knocking on doors saying, hey, sign my proxy or sign this ballot. And then next week somebody else comes by and knocks on the door of the homeowner, and the homeowner says, okay, fine, I'll give it to you. They don't want to be bothered, and so they sign the last ballot that's handed to them. So you really want to have an opportunity for people to change their minds in a community association, particularly because of the political infighting that likely goes on. I don't know if any of you have ever experienced that. It's not as typical in a homeowner association as it is a condo, but in a condo it's usually about the money. The expenditure of funds, the hiring of people, and things of that sort. But nonetheless, that's the new law. And the new law allows for election of directors to be by an action without a meeting. Now that's really confusing and scary to me because typically people can nominate directors at the annual meeting, and they can run for the board, potential candidates for the board, I should say. Now you can do it by action without a meeting, and I see this as a real potential area of abuse, potentially. I'm not sure this is a good idea. Our documents have always provided that you can use action without a meeting except for the election of directors. So I don't think this was a smart move, and I see this as a real problem in community associations. Again, you know, probably in the homeowner association situation, you can't get people to run for the board. You know, you gotta go out and canvass the streets to get people to do so. That's risky business, because all it takes is one director on that board who, as Soupy Sales used to say, has flipped his pizza, and you will have a problem. Because that one director can wreak havoc on the rest of the board. Scare the heck out of the rest of the board members, they all quit, and that one director who has no notion of what's going on and what should go on, and is operating in their own selfish best interests, will take over control. And you don't want that to happen. The bylaws or articles can require that the votes to be cast at a polling place. So it doesn't necessarily have to be at the association clubhouse, or it can be at a designated location. And the new law requires the association to include an action proposed by at least 10% of the members to be included in the ballot. So this may again create conflict issues with a previous section, but again, 10% of the homeowners can put something on a ballot, and that may or may not be a good idea. Generally speaking, these kinds of clauses will be used not necessarily for the betterment of the association, but to deal with internal fighting. That is my prognosis of what is likely to happen here. But nonetheless, that's what the legislature came up with. I don't think they got a lot of input from community association lawyers to do this, and I don't think they appreciated the fact that, for example, condo associations are regulated by a separate condominium act in the state, and that some of these provisions are contrary perhaps to some of the requirements of the nonprofit, or of the Michigan Condominium Act as amended. So these are all things that may or may not affect you in your situation. Okay, let's talk about enforcing deed restrictions. And again, I sort of alluded to this already today. Your job as the board is to run the business of the association. That includes collecting the assessments, enforcing the deed restrictions. 99 out of 100 associations don't consistently, aggressively, or uniformly enforce their deed restrictions, particularly in a homeowners association, for a number of reasons. One of which is it's more loosely formed, it's less capitalized in terms of money. You typically don't have a management company, you may not even have a lawyer, or you use somebody in your community association as your lawyer, which is a bad idea, because if that lawyer doesn't do the job, then you have a dispute not only with a lawyer, but with somebody that lives in your community. So you don't hire people, and we just gave advice to a homeowner association in Wayne County where one of the kids that the association hired didn't get the snow removal opportunity this time, and his father wrote a scathing letter about the maintenance man and the board of directors, and the board was very upset and wanted to know whether, and there was a website started by somebody at that community, and it was generally used as being critical of the board, and what can we do about it? Can we sue him for defamation? Is it invasion of privacy? Well, the board was upset for the employee. But one of the things that I reminded the board about was, don't hire people in your community to do your work. Hire them from outside of your community. Because if they don't do the job or they give you a hard time, at least you're not dealing with somebody that's living there. Oh, but we get a deal from these people in our community. We get a better deal. And this lawyer does it for nothing. And my response is, you get what you pay for. So one of the things that you need to keep in mind in terms of proper governance is don't hire people that have a proprietary interest in a house or a condo in your community. Now, whether we're talking about a condo or a homeowner association, and let me say, I'm sure there are people that are watching this that are living in condos and on boards of directors of condos. So really everything that I've said today absolutely applies to condominiums. And moreover, there may be issues, as I said earlier, between what your bylaws say, what the Nonprofit Corporation Act now says, and what the Condominium Act now says, that could create some controversy or conflict in terms of what are your responsibilities. My guess is that if you have dissidents in your community, they're going to attach themselves to these new provisions to wreak havoc on you. Now, maybe they have a legitimate basis to do that, maybe they don't. But then it's going to become a legal matter as to how we really interpret these provisions and how they interrelate to these other documents and statutes. So the bottom line is, you have deed restrictions, your job is to enforce them uniformly and consistently. You may well have to amend, and particularly now, this should be more than an incentive to have somebody capable, knowledgeable about community association documents, look at your condo and community association documents and see what changes have to be made to the articles of incorporation, your bylaws, your declaration of covenants, your master deed in a condo context. Because now's the time, more than ever, so to speak. Part of the problem that you have as a board, particularly in a homeowner association, is the matter of collecting assessments. They're typically low, relatively speaking, and it's going to cost you money to get somebody to help you collect those assessments. Now, you should not be putting your own liens on. You need to have a collection policy to follow through. You need to have a lawyer who's knowledgeable putting the lien on. If that doesn't do the job, then you may have to consider a foreclosure suit, which you have a secured interest in. You have a secured interest in that unit in most of your documents. Under the Condominium Act, you have a secured interest statutorily. But as a homeowner association, you have a contractual lien that is typically in the deed restrictions. If you don't have that, you are in deep doo-doo, all right? You definitely need to have the right to have that kind of protection. And the reason you have that kind of protection is that it's important that you need to collect your assessments in a timely fashion, because that's the lifeblood of the operation of the association. And if you don't have assessments if you don't have the ability to collect assessments, or you don't collect those assessments, or you let some homeowners get away with it and others not, you're being discriminatory. And by the way, if it turns out that you're being discriminatory to a, quote, protected class, not only do you have a problem collecting the assessments from an equitable standpoint with a judge, but you may end up opening up a can of worms in terms of fair housing issues. So you got to take this stuff seriously. Now, I don't want all of you to resign from the board after this meeting, okay? I mean, but you've taken the time, effort, and energy to serve on the board so that your association is being directed in a proper fashion, in a positive fashion, in a progressive fashion. So don't abdicate your responsibilities because you're going to get your neighbors upset with you, because you have to raise more money. And that is a typical problem in homeowner associations. They're underfunded. And there's a limitation on their ability to collect more money. So you got to change the document. It's a sell job to explain to these members, hey, you get what you pay for. If you want your property to appreciate in value, we've got to have a nice cul-de-sac in front. We have to have flowers. We have to have landscaping. We've got to maintain the community facility, whatever the case may be. Our job is not to bring down the quality of this association to the lowest common denominator because somebody's on a fixed income. Our job is to maintain the aesthetic integrity of the community, to make it better. And board members don't think that way. How cheap can we get away with this? is what they think. They're most of the time penny wise and pound foolish. That's been my experience in 40 years plus of doing this stuff. And for the life of me, I've never understood why board members, and I said this at the beginning of our discussion, why board members who are serving without compensation, because you're volunteers, which means you're not compensated, you don't get appreciation from your homeowners, you devote time from your family and business to serve on the board, and you're personally liable for what you do or don't do, although that may be changing somewhat now under the Nonprofit Corporation Act. But, the bottom line is, why would you stick your neck out without getting the best talent, accounting, insurance, get the best D&O, directors and officers liability policy you can get, the best lawyer that you can get, the best anything? Oh, we don't have the money. Well, my typical response to that has been over the years, you choose not to have the money. Now, that's typically the case in a condo association, because in a condo association, the board typically has unfettered discretion in most instances to raise assessments for maintenance and repair. If they want to build a new Taj Mahal, they may have to get Condo approval for an improvement. But in the typical situation, the board has the right to increase the annual assessment or levy additional assessments to meet the reasonable needs of the association. You may or may not, depending upon the age of your documents in a homeowner association, have that latitude. If you don't, you should. Simple as that. And that's the best I can tell you. You need to have a collection policy and aggressively pursue it. Same with bylaw enforcement. Don't file your own liens, don't play lawyer, don't go to small claims court. If you have the right to collect attorney fees in terms of a collection matter, then avail yourself of that ability. Because the homeowner figures, okay, well, all right, I won't pay the assessment this year. The worst that can happen is I'm going to get stuck paying it next year, and maybe I end up paying 7% or 2% interest, if that. Or maybe there's not even a late charge. However, what ends up happening is if your documents allow for an attorney to collect the attorney fees for the association, then that guy's going to probably pay maybe 3-4 times the amount of the assessment by way of legal fees. And you have that right, and courts enforce that. Okay? So take advantage of the economic power that you have. People forget on boards of directors that the association typically has tremendous economic power. Why? Because let's assume you have 300 units in your community and 300 homes, and you hire a lawyer and he's charging you $300 an hour. What's it costing each homeowner of that association to have that lawyer? $1 an hour. Boards don't think that way. They don't think that way. Meanwhile, you're going after a homeowner who hasn't paid his assessments, who is going to have to hire his own lawyer to represent him, and may end up having to pay all of the legal fees incurred by the association, including 1/300th because he was a member of that association. So boards don't recognize that you can divide up the costs of operation among the number of members of your association. They don't think in those terms, but they should, in my judgment. Okay, fiduciary duties. What does that mean? That means that you are in a position of trust. That means you are held to a higher standard of care, honesty, good faith than a typical homeowner. So a homeowner can say, you know what, please don't raise the assessments. I'm on Social Security, this, and this, or I'm leasing my unit out. I don't want my assessments raised. I don't want you doing anything at this community. You as a board may be in that situation, board member, you may have your own economic problems, you may have all kinds of issues internally, but when you step on that board of directors, as a fiduciary, you have to set aside your personal biases and problems, and think about what is in the best interest of that association as a whole. What is in the best interest of that association as a whole? Not what's in my best interest. You have to avoid conflicts of interest. You have to avoid self-dealing. In other words, if you're in the insurance business, don't submit a bid to the association to get you as the agency. You could probably do it legally if you disclose, but it's not a good idea. You know, if you're on the board and your best friend is a delinquent homeowner, you can't say, no, well, let's not go after him, when you know that we have to go after him as an association. Because inherently you have potentially a conflict of interest. So you need to be wise in terms of how you conduct your affairs. Now, maybe the new statute says taking action or not taking action, maybe that's so broad that it covers this kind of thing. I doubt it. I still think that if you're not operating in good faith, if you're self-dealing, if you're in a conflict of interest, if you're plain stupid, you're going to potentially have a problem. Let me just add a couple more items about relationships between the association and the attorney. There are, you know, I've been doing this a long time, and there are certain things that occur in this in Michigan, and probably lots of other places, in terms of the relationship between the attorney, the management company, and the association. How many of you have a management company here? One or two people, okay. But somebody out in the audience, I'm sure, does. There are a couple of things that I think need to be said. I'm not sure that many community association lawyers will say this kind of thing, but I've never been shy about expressing my opinions and views. First of all, just as in any other relationship with an attorney, you need to have a written fee agreement. The state bar suggests it. In fact, in certain instances, you have to have it if you're on a contingent arrangement with the client, but typically that's not the case in representing community association. Why do you want one? Because you want to know how you're being charged, what your responsibilities are for payment, what is the scope of work of the attorney, et cetera, et cetera. You know, if you don't, there are some community association lawyers that don't have a contract with their associations. They get hired through the management company, and the management company says, oh, we've got a lawyer for you, we'll take care of it. Turns out that lawyer is really somebody the management company is real close to financially, in the sense of getting referrals over and over again. So query whether they're in a objective position. And they'll ask this attorney to come in, and you won't even know maybe who he is. You'll get bills every month that are sent to the management company that they'll pay. So you need to make sure that you hire an attorney who is totally objective and who has your interests in mind, which is their ethical responsibility. And you need to have a fee agreement that sets forth the terms and conditions of that scope of representation. Because otherwise the attorney will say, well, yeah, we did some work for them periodically. No, I had nothing to do with advising them on suing the developer. That wasn't something we were asked to do. It's not in our fee agreement. Well, okay, who are we kidding here? So make sure that you have a written fee agreement with an attorney. When you get billed by the attorney, make sure that attorney gives you a detailed account of what he or she has done. I've seen bills from attorneys where all they describe is general work that was done and a cost. They don't tell you who did the work, what the hourly rate was, and how much time was involved. Now, you're entitled as a client to a detailed statement from your attorney. And if you're not getting it, the attorney may be saying, hey, we're cheaper than the next guy. We're only charging you $200 an hour for our time. But you never can know from the bill because you don't know who did the work, and you don't know what the hourly rate was that was being charged at that point in time, because they may have a varying degree of hourly rates, which they should have, depending upon the experience of the attorney. Now, some law firms over the years have charged the same hourly rate irrespective of how much experience that attorney had. They've sort of gotten away from that because they realize it's not right. You know, they'll come in from a sales standpoint and say, hey, our hourly rate is such and such, you know, lower hourly rate, because boards are susceptible to hiring the cheapest contractor, because that's their job, is to spend as little money at whatever cost in the minds of many. And so what typically would happen is that, you know, the hourly rate for maybe the most experienced attorney would be lower than usual, but all the youngings, so to speak, would be charging the same hourly rate. Last, in terms of the relationship, and it doesn't apply to most of you because you don't have a property manager, and I recommend, by the way, for the record, that you get all the help that you can in running your association, including a competent property manager. Because you need, again, in the context of what I've talked about before, you need all the help you can get to run that business properly so you don't get into trouble and the association doesn't get into trouble. So you want to hire a good property manager. But you want to make sure that that property manager is not in bed with the lawyer. And what I mean by that is that, particularly in the condo world, the property manager will recommend an attorney to the board. And sometimes the property manager isn't as candid as it should be, and he says, well, we have a lawyer, quote unquote. Well, we have a lawyer that we work with, and that lawyer has received 150 associations from us over the years. And then the question is, how is that lawyer, even though he's ethically bound to represent his client, namely the association, how is he able to deal with, let's assume there's an issue between the management company and the association. The management company has not done the job properly. There's a claim. Some lawyers will be candid enough to tell you up front, if there's a dispute between your management company and the association, we won't be able to represent you. Okay, that's fine if they tell you that, but how can they review your management contract then? How can they give you any objective advice? Are they in a position to tell you that your management company hasn't done the job properly? Knowing that if they tattletale on the management company, they may lose tens of thousands of dollars worth of business if they alienate that management company. But that's what goes on. So you need to be sure that the personnel that you hire, whether it's the attorney, the CPA, the landscape contractor, whatever, is beholden to the association and not anybody else. And if you do that, you're going to be okay. And frankly, you need to be aware of that condition being out there, because most associations are oblivious to that. They don't get the connection between the lawyer and the management company, because the management company typically is the first person that the board looks to in recommending an attorney. So, and you know, there are some excellent management companies in this town, and there's some real bad ones. So frequently we're asked to recommend management companies. Frequently we're asked to hopefully review all the management agreement, and sometimes we're asked to sit down and interview with the board the management companies, because I pretty much know most of them in town. I've dealt with them over the years, and sometimes I can ask them questions that maybe the board isn't sensitive to ask regarding the way they do business. Because if they don't do a good job for you, guess what? It ends up in your lap. You can't delegate your liability to the management company. You are responsible as a board for what you do and what you don't do, subject to the new law. Okay, I have spoken long enough, so I'm happy to try to answer any general questions. I'm not here to, you know, respond to an individual legal problem that you have at your community, but I am happy to try to answer, you know, general questions you may have. Just a couple comments. One, somebody asked me about the township. Now, community associations are going to, when there's a legal problem, they will go to whatever length is possible not to have to go to a lawyer, in my opinion. They will call their congressman, they will call the attorney general, they will call their local representative in Oakland County, they will call the township, when in fact they have a legal issue that is internal to their association. 99 out of 100 times you're not going to get any help from those people because they don't have jurisdiction. And one of the things that you need to think about is that your restrictions may be more restrictive than the township or the city's code requirements. So, and let's assume somebody wants to build something in your community and they get a building permit. Oh, we're stuck then. No, you're not stuck. Because even though they got a building permit, if what they're building is in contradiction to or is contrary to the restrictions embodied in your documents, you have authority to go after them, assuming you want to do so and have the money to do so. So the township, sometimes, some of the townships, particularly, you know, in Bloomfield area, they say, well, we're not going to give you a building permit until the association approves it, which I think is not necessarily a good thing either, because I don't think that the township necessarily has that authority, but they sometimes exercise it. But on the other hand, you have to recognize that you are an independent body, that your restrictions and requirements for construction or modification may be more onerous than the townships, and you have a right to enforce those. So let's keep that in mind in terms of issues that come up. Okay, I'm happy to answer any other questions. Yes, sir.
What is the easiest way to get a hold of a copy of the latest amended documents? I suspect we're not up to date at all.
Well, okay. What is the easiest way to get a hold of the statutes? Now, am I suspecting that you're going to read that statute, play lawyer, and make your own changes? Is that what you're thinking? Because that's how most people think.
No, let's not get into that.
Okay. All right. Probably, and my legal assistant, Kay Michael, who's been with me, what now, 6 months? 30 years she's been with us. Probably to go on the legislative website, and they'll get a copy of it. But, you know, it's like me pulling out, you know, if I have heartburn and I go to the medical library at Wayne State and pull out a book on, what do they call it, acid reflux, and I start reading about it. Okay, well, okay, fine. But I'm going to go to a doctor to get a prescription for what I need. And that's another problem with community associations. They think they can do it all themselves. We talked about that earlier. Reading the statute may be of interest to you, but you need to get a lawyer, particularly given the new statute the way it is, to help you through the process, to sit down with the board and to go over with the board these changes and how they affect your community association. And as I suggested earlier, this may be the impetus for you to get a global review of your documents and bring them up to 2015 standards. Okay. Yes, ma'am, in the back.
If you place a lien on a property for non-payment of dues, and the property goes into foreclosure, does your lien have any weight to it, or is the mortgage take precedence, and then you may just be saying bye-bye to your dues, or?
Well, it typically, and I can only say this typically, the documents will probably provide that the first mortgage of record that's recorded on the property before you place the lien on will take priority and will wipe out your secured interest in the property if there's a foreclosure. On the other hand, you have a right, once the sheriff's sale takes place, to collect the back assessments from the purchaser at the sheriff's sale from the date of the sheriff's sale forward. Moreover, that does not eliminate your ability to collect from the homeowner on a money judgment. So you don't have the security of foreclosing on the unit, but you can still go after the homeowner for money damages. Again, it depends on your documents. It depends on the nature of the foreclosure, whether proper notice was given, and a whole series of things. So I'm not here to, tell you that this is the absolute resolution, but typically that's what you have to be confronted with. And we fight with mortgage companies all the time, particularly in the condo context, in terms of priority of the mortgage, vis-a-vis the condo association lien. Yours is typically a contractual lien. I'm told a lot of you in this room have associations that don't even have lien rights, and that's real bad. That means you have real old documents, and your hands are somewhat tied more than they should be. And one other thing, when you redo your documents, it's nice to have a brand new booklet that combines all of your documents together so that you can hand it to your homeowners, and it's not a bunch of old wrinkly pages that are, all full of different amendments, where you have a comprehensive set of restated bylaws and a restated declaration and a restated articles of incorporation, all put together in a nicely covered booklet. And you know what? When I see somebody come in with an old set of documents, that's a red flag to me about the way that association has been run. Now, again, I'm a little more sophisticated than a typical lawyer who looks at this stuff, or even a purchaser. But the bottom line is, if you've got a brand new set of documents with a nice cover on it, everything consolidated together, it makes an impression. Because that's what new subdivisions are doing. That's what new condo developers are doing. Why not bring your community association up to 2015 standards? It's just part of the marketing process. Yeah.
I'll make this brief because sadly, although I don't want to appear to be rude, I do have to dash.
Hang on, can you repeat that for the tape?
Yes, have to dash. Sorry, I don't want to be rude. But very briefly, I'm wondering if you, I found great interest in your description of fiduciary duty and board function. I'm curious if you can draw a distinction between a member of the board of directors, an officer, and a trustee. The way that our particular municipality is arranged has a village set of trustees, and to
Well, they're like the trustees. They run the village, presumably.
Right. And to dovetail with that, I'm sorry to interrupt you, if you can also answer briefly in regard to what the most efficacious way is to pursue updating bylaws and deed restrictions. We've been told by our corporate counsel that it is so onerous and so expensive and such an incredible feat to be accomplished.
Probably because he doesn't do it.
Right.
And so the easy way out is to say, don't do it, or I can't do it. We do it all the time. It's not easy. You need participation from the members, but particularly now with these additional changes to the Nonprofit Corporation Act in terms of action without a meeting, it is doable. It's a sales job. You have to explain to the members. Kay is great at going out to these meetings. She's much more patient than I am sometimes when you have dissidents or ludicrous questions being asked. But generally speaking, you have to inform and enlighten the homeowners as to why it's necessary in their personal best interest to upgrade their documents. I try to distinguish between a director and an officer in a community association. A trustee of a village is sort of like a board of directors of the village. The person is responsible for operating in the best interests of the village. Okay? Same kind of fiduciary responsibility. Yeah.
Just a question. What's a good rule of thumb for an amount to keep in reserve for an association?
It depends on what you have to maintain. In the condo context, the minimum requirement is 10% of the budget on a non-cumulative basis. If you want FHA financing, you may have to have in your budget each year 10% of the budget going to reserves. And so if you have a clubhouse and a pool and things of that sort, you're going to need more money. What I was trying to point out earlier was, irrespective of your maintenance responsibilities, you got to have enough money to withstand somebody who thwarts the bylaws and the restrictions. So, you know, you need to have 20, 30, 40, 50 grand, if nothing else, as a deterrent to that recalcitrant homeowner who says, come sue me. I'm a lawyer. Go sue me. It's not going to cost me anything. And I know you don't have the money. So I'm going to do what I damn well please. That's what you have to avoid. Yeah.
I still want to just take this, the question that came up here a little bit further. I don't really understand. We have problems with our deed restrictions. There's no question about it. I don't know the steps or the process to try to get that
You go
done.
to a lawyer.
Okay, but
You don't pass go. You go to the lawyer.
who goes
immediately.
to the lawyer?
By 3 o'clock this afternoon, you should be in a lawyer's office. Don't even skip lunch. Go right to the lawyer. She's better looking than I am, and I'm going out of town, so.
No, can you honestly, can you help me? Who goes to the lawyer? What
The board.
What do you have to do
the
first?
The board of look, you are on the board, presumably, right?
That's a whole different question. That would be a sidebar
Whoever-
question for you.
whoever
But yes,
the-
let's say yes.
Whoever has the board of directors, hopefully, will be smart enough to know, or have enough pressure put on them by the members to know that they need to get their documents upgraded. Rather than them starting to redraft their own documents and pull somebody else's documents, or talk to their malpractice lawyer in their community who does medical malpractice defense, they're going to go to a lawyer who has some knowledge about community associations, who will then give them a step-by-step process in doing the right thing. He or she will look at their documents, confirm that they need total revision, find out what your changes you want to your deed restrictions. Do you want to add or detract from the number of directors or eliminate a certain number of directors on the board? What deed restrictions you want to change in terms of prohibitions. And then typically what we do is we come up with a first final draft of a new deed restriction and a new bylaw and a new articles of incorporation. We give it to the board of directors, they look at it, they make comments on it, and then we take it back and make those corrections. And then we go through the process of inviting the co-owners to get involved, homeowners to get involved. We'll probably initially amend the articles to make it easier to operate with action without a meeting, and set forth a procedure and a timeline to get the documents approved. Now, sometimes you have to take it to the homeowners more than once or twice. But your argument to the homeowners at that point is, hey, we spent money on getting these things done. We know it's in everybody's best interest to do this. We need your support. That's what she's great at, okay? And so for somebody to tell you it's not worth it, it's, that's a cop-out. That's an absolute cop-out. And I hear that all the time because these guys don't do community association law. I'm not saying it's easy, but it's doable.
No, that's what I was asking for.
Yeah, it's doable.
Ask them what percentage you approve, 51?
Depends on your
Well,
documents.
Yeah, ours is, I don't know, for us to get a dues increase, it's 75%.
That's ridiculous.
Of members.
Yeah.
Not that are present at a meeting or anything like that. It's,
I know, but that makes it impossible to
Right.
raise the document, to change things. And why developers put that in, I don't know, but they did, and particularly in homeowner associations. In the condo world, you can amend your condo docs with 2/3 of the co-owners to approve it. And as I said earlier, the association board in a condo context can raise the assessments generally without any input from the homeowners. Yeah.
What kind of cost would be associated to that? I know you can't give an exact number, but generally, we're talking, what kind of cost in general would be associated with
depends.
doing that? I mean,
I
it
would
depends on
say-
the size of the association, I realize, but are you talking 10,000, 5,000?
I think that sounds good. 5,000 to 10,000. That sounds like a good number. It depends on each project. It depends on each project and what has to be done, how many meetings we have to go to. it's not an exact science in terms of what, because each project has its own particularities that we have to deal with.
Is it based on the number of homes in that area?
Not necessarily. You know, whether you have 10 homes or 1,000 homes, you still have to do the same amount of work to change the documents. You know, it doesn't matter how many units you have in the community, you still have to amend the articles, you still have to amend the bylaws, the deed restrictions, and all that kind of stuff. So the numbers don't necessarily have anything to do with the amount of time and effort that has to be put in, other than, you know, if you've got 10 members, it's, you know, it's a little easier, hopefully, to get the 2/3 or whatever. But not necessarily. Yes, sir. This gentleman here. You, yeah.
Our homeowner association takes advantage and acquires the director's liability insurance that United Homeowners offers. And a couple of years ago, when I first got involved, I'd asked the insurance company to send us a certificate of insurance just for our records, which they did finally after a little resistance. But it names our homeowner association as a certificate holder as opposed to a named insured. Is that any concern or not?
I don't know what certificate holder means, so I can't tell you.
Well, I don't either.
I mean, the name and, well, okay.
That's
So,
fine.
you know what? You need to find that out. You need to call and find out. I presume that you should be the insured on that policy, the association, and you should have directors and officers liability, and you should get the very best that you can afford. Not that you can afford, the very best, period. You know, because why not? Not all D&O policies are the same. There are lots of exclusions in some of these. And, you know, sometimes you're going to get into civil rights complaints, and sometimes you're going to get into defamation complaints. And there may or may not be coverage for that kind of thing. So you need to be careful. You need to have your lawyer look at that policy and see whether it's adequate or not. Talk to your insurance agent or whoever you get insurance through and say, hey, is this the best D&O policy? Does this cover us as broadly as possible? In the back there, way in the back.
Just before we go to that, I'll point out quickly that UHOA did just have a presentation at the last annual meeting by the insurance agent, and I believe, Dave, we're going to have that on the web shortly, if not already. So many of the answers to that are actually available at the UHOA website right now. Okay.
Yeah, in the back.
I have a question probably affects most of us. We're a homeowners association of 207 homes, and I say homes because we probably have 10 to 12 buildable lots that we've never included as part of our association. We've never billed them. We've never asked them to participate in a vote, et cetera. Do you think that's a why? Should we include them, or at this point, I mean, we've been operating since 1950s, and these unbuildable lots we just never have included as part of our association.
Either you're pregnant or you're not.
My wife always tells me my second trimester. I'm supposed to go back my first trimester, so.
So the bottom line is, it's not a matter of your choice, it's what the documents provide for. So now the fact that you haven't done anything since 1950 may preclude you from doing something, but generally speaking, my advice to community associations is better late than never. And this might be, and obviously you're a prime candidate to get your documents upgraded, and maybe at that point in time you deal with that issue to the extent you can.
Okay, I've been putting liens and going to small claims court on behalf of our association.
Kick that lady out.
So so I'm concerned. What
You
will
should be
happen to me?
concerned.
Well, I wasn't concerned till today.
Well, okay.
Tell me what, we don't
Are
have
you
a
a
lawyer
lawyer?
on staff.
No.
No, I'm not a lawyer.
Are you an engineer?
No,
Okay.
I'm just a
Because
volunteer.
lawyers and engineers do this
And
kind of stuff.
regretting it.
All right, the bottom line is, you don't play lawyer. You don't go to small claims court because even though it sounds attractive, it's not a court of record. You can't appeal the decisions. The judges tend to compromise. You need to take advantage of the legal clout that you have. First of all, you want to make sure that the lien, first of all, you want to have a procedure internally where if the homeowner is delinquent, the board or the management company writes a letter. And this procedure then says, okay, then you get a late charge on it. And then maybe the second letter you send out with a late charge. And then you turn it over to the attorney. And the attorney writes a letter, and he says, we're putting a lien on. And if you don't pay it, we're going to foreclose and buy you away. You owe us X number of dollars. And that's the way you do business. It's as simple as that. You don't stick your neck out. You don't play lawyer. You avail yourself of the rights that you have, presumably under your documents. That's 40 years of my experience in telling you that. Yeah, go ahead.
So are you really saying?
You're going to be arrested after this meeting. I've been indicted, you're going to be arrested.
Well, it's nice to know you, sir.
Okay.
The question is, should you really then have a lawyer available to you? I mean, is that kind of what you're saying?
I just don't know the answer to that. I mean, let me think about it for a long time, and then I'll let you know whether I think you need a lawyer or not. Who else? Lady in the back, okay. Okay. Who hasn't had a chance yet? This gentleman, okay.
Now that I have the microphone, I'm going to ask two questions. First of all, we have a deed restriction. It must have been written in 1902.
1902?
1926, go ahead.
Oh, 26.
I mean, just joking. But
Yeah.
anyway, no Jews.
Are you like a resort?
Yeah, no Jews.
Yeah.
No blacks.
No blacks, no
No
Jews.
horses.
No horses.
Blah, blah, blah.
Yeah.
What do you think about that?
I think that we ought to sue your butt. What I said earlier, remember when I said earlier about the fact that you may have old restrictions
Yeah.
that don't allow Jews and don't
Right.
allow blacks or
Right.
whatever. And you've never enforced them, presumably. Maybe you
Right.
did in the old days.
Right,
But the fact that they're there
yeah,
is potential exposure for you. Because somebody could say, somebody looks at these deed restrictions, they're not that sophisticated, they're Jewish, and, they can't, they know that there's a hostile environment. You're a sitting duck, okay,
Well.
for liability. And you need to clean that up, probably by 3:30 today.
okay. My
Okay.
second question, our
By the way, give me the address of all of your members. I'd like to.
Our association charges $30 a year. We have people that haven't paid in 25 years. The only way we collect is either when you die or when you move out.
I think
then the title,
If I were
company-
you, I would leave the county. All right, because you are in for the deepest of doo-doo that I can possibly think of, okay? Because you are the classic.
Yeah.
You haven't raised your assessments in 25 years, it's $30.
Yeah.
You haven't, you got deed restrictions that are illegal, and who knows what else, okay? So.
No, I have a lot of horses in the garage.
You are the textbook example of badness.
Okay.
That's all I can think of.
Well, thank you very much.
Just remember, you get what you pay for, okay?
Do you provide a list of good and bad management companies?
For money, I do, yeah.
For money you do?
Yeah. Because there has to be an attorney-client privilege, Anybody else have any questions that I can add? Yes, ma'am.
If your current set of
your current set of CC&Rs designates a time at which they can be updated. Ours is every 10 years.
But that's another problem.
Do you have to stick with that time frame?
You know, I don't want to give an opinion on that. I think that what I would say is that the attorney that helps you with that will have to be creative and resourceful to deal with that issue.
Okay, and we have 3 different sections, 3 different sets, 3 different time frames,
Well,
which we've
then,
always wanted, of course, to
in
combine.
one subdivision.
Kentmore.
Well, I mean, just, it's one
Oh, one,
subdivision.
yeah, right.
Yeah, well, you know, that's another problem, because developers, you know, unlike condos, up until 1983, which were regulated by the state, and now there are certain requirements in terms of putting something together in the statute, you know, there really isn't any limitation on what developers could do in homeowner associations. There wasn't anybody really overseeing it. The title company could care less. All they care about is getting, you know, ensuring that the mortgage company has a first lien and that you have a ownership interest in the property, but they could care less, nor should they care that much about the rest of the documents. And most people don't get a lawyer when they buy a house, and particularly when they buy a condo, when they should, more than ever. So it's sort of the blind leading the blind, and people get into these things. They don't even know that they're deed restrictions. They don't even get a copy of them. They don't even ask for them. And so once they get into the situation, it takes them years and years to get oriented. The developers sometimes are lax in preparing the members of the homeowner association to take over because they don't care. They just want to sell their units and get out of there. And then, you know, they give favors sometimes to their purchasers to make changes that are in violation of their own restrictions that they created. So there's a lot of abuse and a lot of naivete in the community association world. And it creates problems later for everybody, and that's what keeps us busy.
Well, it's kind of the second part of my question. I mean, obviously, this has been going on for 60 years or so, and you've had, you know, volunteer after volunteer after volunteer, and different sets of volunteers have enforced things differently, and then someone new comes in and says,
Reinvent the wheel.
you have not been following the rules.
Right.
Now, all of a sudden, you know, you're trying to follow the rules.
Better late than never.
Okay, that was my question. If it's been violated before and
It's a
suddenly
problem
somebody new,
Yeah, it's a problem potentially. They'll claim that the association is stopped, as a legal term, from taking action, that they've waived their rights and things of that sort.
right?
Again, if you have a creative, thinking outside of the box attorney who may be in a position then to help you deal with that problem.
And
That's all I
will
can
an
tell you.
overhaul of the documents then help
Well, sure.
bring you to a
Oh, yeah,
new
yeah,
playing field
yeah.
and say, okay, people,
And-
these
and-
are the rules?
And you need to enlighten the people as to these rules are for your benefit.
Right.
You know, they're not for the board's benefit. The board doesn't, you know, if the board levies an assessment, another argument, if the board levies the assessment, they gotta pay it too. You know, it's not like they're free from it, and they shouldn't be free from it. I hope you're not giving board members compensation when they're supposed to be volunteers, which happens in many places.
Okay, thank you.
What else? I'm gonna add, okay, go ahead.
This is a real quick one, but you mentioned something about remote voting. Does that require us to do anything to enable that?
Yeah.
I mean, do we have to put in some sort of a website that allows them to
No, no.
vote securely or anything like that?
Oh, well, technically, I can't tell you. Technologically, I'm not sure. I think, I guess you could do remote voting that way. I don't want to give you an opinion on that. I do know that you can, under certain circumstances, vote electronically, correct?
If your documents are amended to permit it.
Right.
I mean, does that mean someone can telephone in a vote, or I don't know what remote voting, what the definition of remote voting is?
Probably using a website, but I can't tell you what they would consider to be satisfactory. You know, they talk about the term electronic, whatever that means. So I think you have to understand what electronic means in the context of what they've said. So I don't want to tell you that, I don't want to tell you at this point.
It's kind of
in this fashion. So faxing or emailing or whatever the case may be would be defined and specified, and you would follow your documents exactly. So there would be no guesswork.
Okay, but there could be an exposure or cost to the association to implement this new requirement.
What do you think?
It's kind of a rhetorical question, I guess.
Yes. Does that bother you that there's a cost that may be implemented to do this?
Actually, I'm all for spending money,
But
that doesn't make me in the majority or part of that 75. Doesn't make you popular.
well, but the problem, that's.
I mean, I've had to do the door-to-door thing.
No,
and stuff.
I think that
Raised before.
the problem always is first to get the board to understand their duties, that you have to spend the money. And then, once you've enlightened the board, or they've become enlightened, then you've got to work on the homeowners. And it's much more difficult in a homeowners association because of all these high requirements to get something passed. And that's the major disadvantage you're in. But it's not necessarily lethal in terms of what you can do and what you can't do.
In our case, it's the board of people that want to spend them, and they're the people that care. That's why, they got involved because they care. The fact that you gotta get 75%, and it's,
Then you got to work hard and be creative.
done it for 10 years, 15 years.
Okay, anybody else? Yes.
To go back to the question before Bill's question about, associations letting things go by and then you want to fix it and really abide by what your bylaws or deed restrictions are. It is possible to put something in your bylaws that would say that nobody's grandfathered. If they didn't get it, that doesn't mean that.
You mean they are grandfathered?
They're not grandfathered.
They're not grandfathered.
Or are, either way. you
Yeah,
put it,
generally
I
speaking,
suppose.
if you have a provision that says, you're allowed 3 dogs and you decide to go down to 1, you're gonna grandfather those other 2 dogs until they,
Well, it could go either way, though. But
by the way, we have legal beagles in our office, unlike many other firms. I try to distinguish myself from the other community association lawyers. We have 2 legal beagles that are associated with us. They're on our website. They have their own columns, and they also are featured in Condo Living too. In fact, one of them is pictured on the title, on the cover of the book. So we think we're different and unique for that reason.
I'm so glad.
Yeah.
The other thing is, I get the most complaints about associations trying to enforce their deed restrictions, and then one of their members goes to the ZBA and asks for a variance, and even though the architectural committee or the board says we don't want it, the ZBA does it anyway, and so what is the recourse?
So
there?
what? I said earlier that the fact that the township or municipality gives you a building permit or a variance doesn't require the association to have to do so. You can still enforce your restrictions.
By going to court.
Well,
There's no-
by
there's no
going
in
through the
between.
process, of bylaw enforcement, which again, you need to have a written policy in place to do that, so you treat everyone uniformly. You have your attorney write a letter to the homeowner saying, you haven't complied with the deed restrictions about approval from the Architectural Control Committee, therefore, you're doing something improper, stop doing it. He tells you to go jump in a lake, you have to go to court, if necessary, and get an injunction. Now, that's why you have to have funds available to deal with that. And so this argument, hey, we can't enforce our bylaws, is not really accurate. They choose not to want to enforce their bylaws because they don't want to spend the money, or they don't have a lawyer, or who knows what. So the bottom line is, they have a legal responsibility to enforce those documents irrespective of what the township says or does. Now, if the township turns it down, that's one thing, okay? But if they don't turn it down, that doesn't mean that the association is out of the ballpark. they can still make an issue out of it and should, if this is a variance or in violation of the deed restrictions, unless the Architectural Control Committee or the board has in its wise discretion the ability to grant that variance itself. Okay?
Thank you.
I don't have any more answers. I'm all out of answers.
The one I have one last
All right,
question.
he's got couple more questions.
One last question. If the association had no income other than members' dues, but gained a minor amount of interest income from their bank deposit, less than $15, must they file with the IRS?
I don't know. Probably not, but talk to their accountant. I don't know.
And Bob, I'm going to throw.
But they should, if they don't have any other income like that, they should start selling cookies.
I'm going to throw one more. You've mentioned equitable enforcement, having procedures in place and so on. What about consistency when boards are replaced? As the directors change out from one to the next and the common belief, well, the past board did this, but we're a new board, we don't have to honor their agreements and so on. For instance, if you have an architectural board without a specific architectural guideline that exercises its discretion and says to a prospective home buyer, you can't add feature X to this fixer-up house should you buy it. The deal falls through. The board changes out, you get a new architectural control, someone else wants to add the same feature X to their home, approved, no problem, and the seller who lost the deal goes, wait a minute.
Well, that's an interesting legal issue, which I don't want to opine on necessarily, other than to say that the biggest problem in community associations is the lack of continuity on the board. And generally speaking, since board members drink a lot, we suggest that they be staggered. No, there should be staggered terms because you don't want a total turnover of the board at one point in time. Now, in some associations, the same guy has been running the association for 25 years with an iron fist like Fidel Castro. You don't necessarily want that. On the other hand, you want people that are familiar with the procedures, familiar with what's going on. That's why sometimes you want somebody who's been there for a long time, not only on the board, but say your managing agent or your legal counsel. You know, if you're some of my associations I've represented for 40 years through, tens of different boards, tenures. So, you want to have some consistency. You don't necessarily have to reinvent the wheel. That's why we have this 12-pack, frankly, because it puts into place a collection policy, a bylaw enforcement policy, modification agreements. So if a new board comes into place, they'll have a written agreement or a written procedure in place as to how they collect assessments. So if they want to change the late charge fee from $10 to $15 an hour, they can do that without totally revamping the whole collection policy. So the more you have in writing as a procedure adopted by the board, code of conduct, these other things that we have in this 12-pack, the longer you have that in place and the more you have in place, the better chance that the transition of control of the board of directors will run more smoothly. Okay?
Are there any more questions out there? Now's the time.
Okay, thank you for inviting me. I appreciate it.